Corporate law is the study of how shareholders, directors, employees, creditors, and other stakeholders such as consumers, the community and the environment interact with one another. Corporate law is a part of a broader company's law. Other types of business associations can include partnerships, or trusts, or companies limited by guarantee. Under corporate law, corporations of all sizes have separate legal personality, with limited or unlimited liability for its shareholders. Shareholders control the company through a board of directors which, in turn, typically delegates control of the corporation's day-to-day operations to a full-time executive. Corporate law deals with firms that are incorporated or registered under the corporate or company law of a sovereign state or their subnational states. The four defining characteristics of the modern corporation are: separate legal personality of the corporation, limited liability of the shareholders, shares, delegated management. The board of directors delegates day-to-day management of the company to executives. In many developed countries outside of the English-speaking world, company boards are appointed as representatives of both shareholders and employees to co-determine company strategy. Corporate law is often divided into corporate governance and corporate finance. Corporate law in context. Definition: the word corporation is generally synonymous with large publicly owned companies in the United States. In United Kingdom, company is more frequently used as the legal term for any business incorporated under the Companies Act 2006. Large-scale companies will be PLCs in the United Kingdom and will usually have shares listed on a stock market. In British legal usage, any registered company, created under the Companies Act 2006 and previous equivalent legislation, is, strictly, a particular subcategory of the wider category, corporation. Such a company is created by the administrative process of registration under the Companies Act as a general piece of legislation. A corporation, in this British sense, can be a corporation sole which consists of a single office occupied by one person, e.g., the monarch or certain bishops in England and Wales. Here, the office is recognized as separate from the individual who holds it. Other corporations are within the category of corporation aggregate, which includes corporate bodies created directly by legislation such as the Local Government Act 1972, universities and certain professional bodies created by royal charter, corporations such as industrial and provident societies created by registration under other general pieces of legislation, and registered companies which are the subject matter of this article. In the United States, a company may or may not be a separate legal entity, and is often used synonymously with firm, or business. A corporation may accurately be called a company. However, a company should not necessarily be called a corporation, which has distinct characteristics. According to Black's Law Dictionary, in America a company means a corporation, or, less commonly, an association, partnership or union, that carries on industrial enterprise. The defining feature of a corporation is its legal independence from the people who create it. If a corporation fails, its shareholders will lose their money, and employees will lose their jobs, though disproportionately affecting its workers as opposed to its upper executives. Shareholders are not liable for any remaining debts owed to the corporation's creditors. This rule is called limited liability, and it is why corporations end with limited. In the words of British Judge Walton J., a company is only a juristic figment of the imagination, lacking both a body to be kicked and a soul to be damned. But despite this, under just about every legal system in existence and as per international norms, corporations have the same legal rights and obligations as actual humans. Corporations can exercise human rights against real individuals and the state, and they may be responsible for human rights violations, just as they are born into existence through its members obtaining a certificate of incorporation. They can die when they lose money into insolvency. Corporations can even be convicted of criminal offenses, such as fraud and manslaughter. History. Although some forms of companies are thought to have existed during ancient Rome and ancient Greece, the closest recognizable ancestors of the modern company did not appear until the 16th century. With increasing international trade, royal charters were granted in Europe to merchant adventurers. The royal charters usually conferred special privileges on the trading company. Originally, traders in these entities traded stock on their own account, but later the members came to operate on joint account and with joint stock, and the new joint stock company was born. Early companies were purely economic ventures. It was only a belatedly established benefit of holding joint stock that the company's stock could not be seized for the debts of any individual member. The development of company law in Europe was hampered by two notorious bubbles in the 17th century, which set the development of companies in the two leading jurisdictions back by over a century in popular estimation. Modern company law. But companies, almost inevitably, returned to the forefront of commerce. Although in England, to circumvent the Bubble Act 1720, investors had reverted to trading the stock of unincorporated associations, until it was repealed in 1825. However, the cumbersome process of obtaining royal charters was simply insufficient to keep up with demand. In England there was a lively trade in the charters of defunct companies. However, procrastination amongst the legislature meant that in the United Kingdom it was not until the Joint Stock Companies Act 1844 that the first equivalent of modern companies, formed by registration, appeared. Soon after came the Limited Liability Act 1855, which in the event of a company's bankruptcy limited the liability of all shareholders to the amount of capital they had invested. The beginning of modern company law came when the two pieces of legislation were codified under the Joint Stock Companies Act 1856 at the behest of the then Vice President of the Board of Trade, Mr. Robert Lowe. That legislation shortly gave way to the railway boom, and from there the numbers of companies formed soared. In the later 19th century, depression took hold, and just as company numbers had boomed, many began to implode and fall into insolvency. Much strong academic, legislative and judicial opinion was opposed to the notion that businessmen could escape accountability for their role in the failing businesses. The last significant development in the history of companies was the decision of the House of Lords in Salomon v. Salomon & Co., where the House of Lords confirmed the separate legal personality of the company, and that the liabilities of the company were separate and distinct from those of its owners. In a December 2006 article, The Economist identified the development of the joint stock company as one of the key reasons why Western commerce moved ahead of its rivals in the Middle East in post-Renaissance era. Corporate legal personality. One of the key legal features of corporations are their separate legal personality, also known as personhood or being artificial persons. However, the separate legal personality was not confirmed under English law until 1895 by the House of Lords in Salomon v. Salomon & Co. Separate legal personality often has unintended consequences, particularly in relation to smaller, family companies. In B.V. B. 1978, FAM 181, it was held that a discovery order obtained by a wife against her husband was not effective against the husband's company as it was not named in the order and was separate and distinct from him. And in Macora v. Northern Assurance Co. Limited, a claim under an insurance policy failed where the insured had transferred timber from his name into the name of a company wholly owned by him, and it was subsequently destroyed in a fire, as the property now belonged to the company and not to him. He no longer had an insurable interest in it and his claim failed. However, separate legal personality does allow corporate groups a great deal of flexibility in relation to tax planning, and also enables multinational corporations to manage the liability of their overseas operations. For instance, in Adams v. Cape Industries plc, it was held that victims of asbestos poisoning at the hands of an American subsidiary could not sue the English parent in tort. There are certain specific situations where courts are generally prepared to pierce the corporate veil, to look directly at and impose liability directly on the individuals behind the company. The most commonly cited examples are where the company is a mere facade, where the company is effectively just the agent of its members or controllers, where a representative of the company has taken some personal responsibility for a statement or action, where the company is engaged in fraud or other criminal wrongdoing, where the natural interpretation of a contract or statute is as a reference to the corporate group and not the individual company, where permitted by statute. In many jurisdictions, where a company continues to trade despite foreseeable bankruptcy, the directors can be forced to account for trading losses personally. Capacity and powers. Historically, because companies are artificial persons created by operation of law, the law prescribed what the company could and could not do. Usually this was an expression of the commercial purpose which the company was formed for, and came to be referred to as the company's objects, and the extent of the objects are referred to as the company's capacity. If an activity fell outside of the company's capacity, it was said to be ultra vires and void. By way of distinction, the organs of the company were expressed to have various corporate powers. If the objects were the things that the company was able to do, then the powers were the means by which it could do them. Usually expressions of powers were limited to methods of raising capital, although from earlier times distinctions between objects and powers have caused lawyers difficulty. Most jurisdictions have now modified the position by statute, and companies generally have capacity to do all the things that a natural person could do, and power to do it in any way that a natural person could do it. However, references to corporate capacity and powers have not quite been consigned to the dustbin of legal history. In many jurisdictions, directors can still be liable to their shareholders if they cause the company to engage in businesses outside of its objects, even if the transactions are still valid as between the company and the third party. And many jurisdictions also still permit transactions to be challenged for lack of corporate benefit, where the relevant transaction has no prospect of being for the commercial benefit of the company or its shareholders. As artificial persons, companies can only act through human agents. The main agent who deals with the company's management and business is the board of directors. But in many jurisdictions, other officers can be appointed too. The board of directors is normally elected by the members, and the other officers are normally appointed by the board. These agents enter into contracts on behalf of the company with third parties, although the company's agents owe duties to the company to exercise those powers for a proper purpose. Generally speaking, third parties' rights are not impugned if it transpires that the officers were acting improperly. Third parties are entitled to rely on the ostensible authority of agents held out by the company to act on its behalf. A line of common law cases reaching back to Royal British Bank v. Turquand established in common law that third parties were entitled to assume that the internal management of the company was being conducted properly, and the rule has now been codified into statute in most countries. Accordingly, companies will normally be liable for all the acts and omissions of their officers and agents. This will include almost all torts, but the law relating to crimes committed by companies is complex, and varies significantly between countries.